Hi, I'm Steve Bohm, head of the Capital Markets and Investment team at Eversheds Sutherland. I'm here with Max Lacona, an associate on our team, and Max is going to give us an overview of the BDC market today. Max, what is a BDC?
Thanks, Steve. A BDC is a type of closed-end investment company that is required to invest at least 70% of their assets in private or thinly traded U.S. companies in the form of long-term debt or equity capital. BDCs were created by the 1980 amendments to the 1940 Act. In the 70s, private equity and venture capital firms believed that the small private investment company exception under Section 3C1 of the 1940 Act limited their ability to provide financing to small early-stage companies. A perceived crisis in the capital markets during the 70s spurred the passage of the 1980 amendments in order to increase the flow of capital to small businesses by allowing private equity to be sold in the public markets.
Max, what are some of the characteristics of BDCs?
BDCs are allowed to take advantage of regulated investment company, or RIC, tax status, which provides favorable tax treatment so long as certain income distribution, source of income, and diversification requirements are met. BDCs are a special type of closed-end fund that are incentivized under the 1940 Act to provide capital to early-stage companies and provide retail investors with access to investments in growth companies to which they would not otherwise have access. For regulatory purposes, it is a hybrid between an investment company and an operating company in that it is regulated under the 1940 Act, but also must file periodic reports with the SEC like public operating companies. Traded BDCs have access to public capital markets and are traded on national exchanges such as the New York Stock Exchange and Nasdaq. BDCs have a reduced burden under the 1940 Act as compared to closed-end funds, such as lessened restrictions on asset coverage requirements and lessened restrictions on affiliated transactions. The externally managed BDC model permits management fee and carried interest incentive fee structure. BDC portfolios are typically diversified and therefore reduces some of the risks typically associated with private equity investments.
The BDC market has evolved over the years. Can you give us a little outline of how that has taken place?
Sure. Prior to 2003, most BDCs were internally managed. Then in 2004, Apollo, which operated as an externally managed BDC, raised $930 million in less than 3 months, which ignited growth in the externally managed model. Currently, there are 91 externally managed BDCs and 7 internally managed BDCs. In 2008, Franklin Squared launched the first non-traded BDC. In 2011, TPG launched the first private BDC. As of August 2020, BDC assets aggregated approximately $121 billion. There are currently 98 BDCs in operation, 50 that are traded with $34 billion in market cap and $89 billion in aggregate assets, 34 private BDCs with $21 billion in aggregate assets, and 14 non-traded BDCs with $10 billion in aggregate assets. Although a majority of BDCs are traded, since 2016, the BDC industry has largely shifted to the private BDC model, and this trend appears to be continuing.
Thank you, Max.
Thanks, Steve.
Today, we're going to talk about types of BDCs. I'm Cynthia Cruz, a partner in the Capital Markets Group, along with Taylor Davidson, who's an associate who works with us with BDCs, and she's going to explain the various structures to you. Taylor, what are the types of BDCs out there?
There are 3 types of BDCs out there. There's the traditional structure, a traded BDC. In this situation, the shares of the BDC are listed on an exchange via an initial public offering, which allows shareholders easy access to liquidity. These traded BDCs have an indefinite lifespan, and there's approximately 50 of them in existence right now. The second type of structure is non-traded BDCs. This structure was commonly used by REITs and was initially introduced in 2008. A non-traded BDC offers its shares in a continuous public offering up to a preset certain amount through a network of broker-dealers. Non-traded BDCs have regular closings, usually weekly or monthly, through which investors may purchase shares. Non-traded BDCs usually offer shareholders liquidity through regular repurchase events like a quarterly tender offer. And the structure usually has an investment period after which the fund will be listed, merged, or wound down. This form of BDC peaked in 2014 before dropping off, and there are currently about 14 non-traded BDCs in existence. The newest BDC structure is the private BDC. The first private BDC was launched in 2011. They've grown increasingly popular every year. There's approximately 34 in existence at the moment. Private BDCs are a hybrid between a private fund and a traditional BDC. Private BDCs, offer their shares to accredited investors under Regulation D, generally relying on subscription agreements and a capital call structure, which allows investors to make a capital commitment, which is then drawn down on whenever an investment opportunity arises. There's little liquidity for private BDC shareholders, although some may offer repurchase programs, and like non-traded BDCs, this structure is usually built with a 5 to 7 year lifespan, after which it's merged, listed, or wound down.
So what is the process for establishing each of these types of BDCs?
Sure, before we get into the specific types of BDCs, I think it's good to talk about some general formation considerations that apply to all three types. First, formation and structuring issues. For example, will there be a portfolio acquisition or formation transaction? BDCs may start with or without an initial portfolio, and in some cases, an initial portfolio is acquired from an affiliated fund. These transactions may require additional review and discussion with the SEC. There's also some tax considerations related to the timing of the transaction and the company's BDC and RIC status. Individuals should also consider any necessary exemptive relief. For example, if the BDC is on a platform and has affiliated funds it would like to co-invest with, the SEC will need to grant exemptive relief. At times, a private BDC may rely on existing exemptive relief that a platform has. That is a consideration. If the BDC will be externally managed, the investment advisor will need to be formed if it's not already in existence, and that can be an additional registration process. Finally, you'll need to develop compliance and corporate governance programs. All of these structures have several things in common. This includes board structure and responsibilities, independent directors, valuation, etc. They also have the same SEC reporting requirements under the 1934 Act. This means Form 10Ks and 10Qs, and they're subject to compliance with the governance requirements of the 1940 Act. Finally, for traded BDCs, they are subject to some additional compliance and corporate governance requirements related to the exchange on which they're listed. And then the last two things, more technical, each will need to select service providers such as custodian, transfer agent, administrator, and then organize the entity itself, which is usually formed as a Delaware corporation or a Maryland corporation.
So that all applies to all of the structures for the most part. What is the difference, or what are some of the things you need to do if you're doing a traded BDC versus some of the others?
Sure. For a traded BDC, you begin your SEC registration by filing a Form N2, and this is a multi-step process. You file an initial registration statement, you receive SEC comments within 30 days, at which point you file an amended N2 which responds to those comments, and that cycle can repeat. Usually that process takes about 1 or 2 quarters. Under the Jobs Act, emerging growth companies, which many BDCs qualify as, may submit an initial registration statement confidentially, which minimizes the market and reputational risk. You then register a class of securities under the Exchange Act, apply to list securities on the Nasdaq or New York Stock Exchange or other exchange, file a Form N54A, which is what makes the election to be regulated as a BDC. And then lastly, the registration statement is declared effective by the SEC. If the BDC is going to be doing a portfolio acquisition or formation transaction, this process may require an audit.
Right. And then how does that differ for the non-traded BDCs, that process?
The process is largely similar for non-traded BDCs, the same Form N2 cycle, N54A to elect BDC status, etc. However, non-traded BDCs do have additional requirements. They are subject to additional FINRA review, and because they are doing a continuous offering, they must register in each state in which an offer or sale is made. So this means that non-traded BDCs must make state securities filings, which are often referred to as blue sky filings, in each state in which they're offering in, so that the state securities commissions may review the offering and ensure that the BDC is complying with state securities laws. Additionally, non-traded BDCs need to file prospectus supplements periodically to report on material events and updates. Some of this burden has been alleviated by the new offering reform rules, which allow incorporation by reference.
And what's the difference then? I think the last one you mentioned was private BDCs.
Yeah, so for private BDCs, instead of filing a Form N2, a private BDC files a Form 10 to register its shares. And a Form 10 is an automatically effective registration statement. It can go effective in as few as 60 days, which is a significantly shorter process than the Form N2 process. And then the BDC also prepares a private placement memorandum and a subscription agreement, which is distributed to investors. And the PPM is updated as material events arise. Private BDCs do need to make some state notice filings, but these are less burdensome than the full blue sky review that the non-traded BDC goes through, excuse me.
So how do you decide between these different structures? What are some of the advantages and disadvantages?
Sure, so let's run through the advantages and disadvantages first. For traded BDCs, some of the advantages are investor liquidity as an exchange traded company. They're available to all investors, and there's an infinite lifespan. Some disadvantages is the listing process, which can be a little time consuming, and being a public company is not without its expenses. There's also the additional burden of exchange, corporate governance, and disclosure requirements. And the market price of traded BDCs can be subject to some volatility. Non-traded BDCs, some advantages, they enable investors that meet certain suitability requirements, not quite as high as accredited investors, to participate in pre-IPO investing, which is unique. And they in large part avoid market price volatility because the offering price is tied to the net asset value of the non-traded BDC, and that provides some stability. And the continuous offering provides a steady flow of capital for investment. Finally, there's some optionality regarding winding down, and liquidity event usually occurs after 5 to 7 years, but there's some movement there. And the shares are not listed on exchange, so you're avoiding the time of and expense of the listing process, but the offerings are registered in each state in which an offer and sale is made, that blue sky registration process we talked about, and that can mean some additional fees and time. There is some limited liquidity for investors, quarterly repurchase programs usually. And then compared to a private BDC, which has some good advantages and disadvantages, the private BDC is really melds the flexibility of a private fund with the advantages of a BDC. So this means optionality on liquidity events, the capital call structure, which allows drawdowns as investment opportunities arise, and the shorter registration process under Form 10. They are limited to accredited investors only, which can be a high standard, but the SEC did recently adopt amendments to the accredited investor definition, which will expand that pool. And there is limited shareholder liquidity during the investment period.
Wow. So how do we recommend what people should be doing, or what is the market looking at? what are some of the ideas of how we would talk to someone who wants to start one up?
Yeah, I think it's really important to consider your management structure, how you'd like to raise capital, and just your distribution channels. All of those play an important role in deciding which structure works best for you. And some structures work best for everyone.
Okay, thank you so much.
We're now going to have Sarah Sabor, an associate on our capital markets and investment team, talk about regulatory and reporting requirements for BDCs. Sarah, can you talk a little bit about the reporting requirements for business development companies?
Absolutely. So BDC is required to make periodic reports, which include your annual, your quarterly, and your current reports. Your current reports will be triggered based on certain events occurring. A BDC is also required to file proxy statements in connection with soliciting votes from stockholders. Your annual and your quarterly reports are going to include management's report on internal controls over financial reporting. And all of these filings are required to comply with Regulation FD, Sarbanes-Oxley Act, as well as the company's disclosure controls and procedures.
Thank you, Sarah. Can you now discuss a little bit the specific financial reporting disclosures that are required for business development companies?
Absolutely. So a BDC's a board is responsible for determining the fair value of its investments in accordance with its valuation policies and procedures. And your financial statements will therefore include a schedule of investments that's going to include details about each portfolio investment, including the name of the portfolio company, the maturity of that, the maturity date, the interest rate, as well as the fair value. In addition, your balance sheet is going to include information regarding the investments held in control investments, investments in affiliates, and investments in non-affiliates, as well as include details on an aggregate basis of the fair value hierarchy, so level 1, level 2, and level 3 assets. It's worth noting that most of the BDC's assets are held in level 3 assets.
Thank you, Sarah. BDCs are generally required to have at least 70% of their assets in so-called qualifying assets. Can you tell us what those qualifying assets are?
Sure. A qualifying asset is a security held by an eligible portfolio company, which is a U.S. company that is neither an investment company nor an investment company that is excluded from the definition of an investment company under Section 3C. So that's going to include your 3C1 and 3C7 funds. In addition, the company securities can't be listed on a national securities exchange, but if it is, the securities, the aggregate market cap must be less than $250 million.
There are 3 types of affiliate relationships that the 1940 Act deals with. One is what we call a close affiliation. Then there's a remote affiliation, and then there's no affiliation at all. Can you describe these requirements and also talk about what would be required for BDCs to engage in transactions with affiliates?
Absolutely. When you're looking at these affiliated relationships, it's very important to sit down and understand what kind of transaction we're discussing. We're typically referring to selling securities to affiliates, purchasing securities from affiliates, borrowing from the BDC by affiliates, co-investing in joint transaction, and depending on the nature of affiliation, as you mentioned, a transaction with one or more affiliates would require approval by a majority of the board, including the majority of its independent directors, and this would be in the case of a remote affiliation. And a good example of a remote affiliate is a 5% holder of a BDC. In the case of a close affiliation, so an example would be a transaction with the BDC's investment advisor, an SEC exemptive release would be required.
Thank you, Sarah. The 1940 Act imposes a number of other regulatory requirements on BDCs. Can you walk us through some of those?
Yeah. So a BDC, I'm going to highlight some of the key requirements. There's others. First, the BDC has to have a board, a majority of the board needs to be comprised of persons who are not interested persons. A BDC must maintain its securities and similar investments, including cash and custody. A BDC must maintain a bond issued by a reputable fidelity insurance company to protect against larceny and embezzlement. The amount of the coverage is going to be dictated based on the BDC's gross assets, which is set forth in a schedule in the 1940 Act. And finally, a BDC must maintain and enforce a code of ethics that, among other things, will require the reporting of securities and transactions held by directors and officers of the BDC.
Thank you, Sarah. Are there requirements relating to the ability of investment funds investing in BDCs and BDCs investing in investment funds?
Yes. A BDC may not invest more than 3% of its outstanding voting securities in an investment company, more than 5% of its total assets in an investment company, and more than an aggregate of 10% of its total assets in investment companies. When we're referring to investment companies in this context, that's going to include not only registered investment companies, but also 3C1 and 3C7 funds. In addition, neither a public or private investment funds may invest more than 3% in the outstanding voting stock of the BDC.
Sarah, can you walk through some of the compliance requirements for BDCs?
Yes. A BDC must appoint a chief compliance officer, and one of the primary roles of the CCO is to oversee the compliance program of the BDC that is designed to prevent the violation of federal securities laws. The compliance program will be reviewed on an annual basis to ensure that it's being adequately implemented and that there's no additional modifications that need to be made. In the case of an externally managed BDC, its investment advisor is also required to implement policies and procedures that, among other things, subject its advisors, employees to a code of ethics. As an SEC registrant, the BDC is also subject to regular exams by the SEC.
What are some of the other limitations on BDC activities, Sarah?
Two important limitations that I'll highlight is the first being that a BDC may not sell its common stock below NAV without stockholder approval. The stockholder approval is good for 1 year, and over time what we've seen is the market imposes other limitations on this approval. So one being, typically you'll see BDCs seeking this approval will include a limitation on the percentage of outstanding stock sold below NAV, as well as the percentage in which the common stock is sold below NAV. The second limitations that BDCs are subject to is that, as we previously mentioned, a BDC is required to obtain exemptive relief in order to, among other things, co-invest among affiliates, own registered investment advisors. In the case of internally managed BDCs, issue restricted stock to officers and employees, and issue common stock options to its independent directors. To the extent the BDC also has a wholly owned SBIC subsidiary, to exclude the leverage from the asset coverage would also require exemptive relief. Depending on the nature and the complexity of the exemptive relief, a routine application will typically take 6 months, with the more novel relief taking up to 18 months.
Thank you, Sarah. As we know, many BDCs are traded on either Nasdaq or the New York Stock Exchange. Can you talk about how the rules of those exchanges would impact BDC operations?
There are some variations between the Nasdaq and the NYSE. I'll highlight the ones that overlap. One being that a BDC would be required to have an audit committee comprised solely of independent directors. Director nominees would be required to be nominated or recommended by a nominating committee, or solely by independent directors of the board. A BDC would also be required to adopt a code of business conduct and committee charters, all of which would be posted online.
In March 2018, Congress passed some very important legislation that affects BDCs. A year later, the SEC passed rules that would implement that legislation. And as of August 1st of this year, those rules came into effect. Can you describe how this important series of rules has affected BDCs?
This was a big win for BDCs. It was a long time coming, and one of the things that it has done is put BDCs in parity with operating companies with respect to the registration, offering, and communication processes. So now you're seeing a shelf offering process that includes short form N2 that allows for both forward and backwards incorporation. So it's going to reduce the size of your registration statements and your prospectuses. Allow for BDCs to get into the market much quicker. You're also allowing BDCs the ability to qualify with these and allowing for immediate or automatic shelf effectiveness of certain filings for in connection with continuous offerings. And finally, the communication prospectus delivery requirements are now on par with operating companies, allowing for BDCs to have more flexibility in the ways they communicate to the market.
Well, thank you very much, Sarah. That was very helpful.
Thank you.
Hello. Now we're going to talk about management and operational considerations for BDCs. We have with us Darius Ravengar, an associate in the Capital Markets Group who works with BDCs on a day-to-day basis. So Darius, explain to me what I mean by management and operational considerations for a BDC.
Certainly, Cynthia, and thank you for the introduction. So in this portion of the presentation, we're going to be discussing internally and externally managed BDCs, fair valuation of investment portfolios, and tax treatment as a regulated investment company, or RIC.
So explain to me what the difference is between an internally managed and externally managed structure.
Yes, certainly. So as you mentioned, there's two structures for BDCs, the first being an internally managed structure and the second being an externally managed structure. In the internally managed structure, the BDC directly employs and compensates its officers and other employees. And in compensating its officers and employees, the BDC will pay the officers and employees a base salary, a bonus, and will have either an equity incentive plan or a profit sharing plan. Now I note that BDC, internally managed BDC, can only have an equity incentive plan or profit sharing plan. The 40 Act prohibits having both. It's also worth noting, and BDC should be aware of their bonus structures, because a bonus structure that is formulaic and is based in part on profits can be deemed a prohibited profit sharing plan. The way to remedy this is to make sure that the bonus structure or the bonus plans have an element of discretion in them. So as I mentioned, BDCs can have equity incentive plans. Now, in order to have an equity incentive plan, the BDC must first receive an SEC exemptive order and second receive shareholder approval. Although I will note that some BDCs can have an equity incentive plan that only provides for the issuance of options to officers and employees without an exemptive order. All that's required in that case is shareholder approval. More commonly, BDCs will have equity incentive plans for the officers and employees that permits the issuance of options as well as restricted stock. And they may also have a separate plan that provides for the issuance of options and restricted stock to directors. Now, in that case, you have to receive an exemptive order prior to going to stockholders for approval of the equity incentive plan. Further, BDCs, because they directly compensate their employees, they're subject to certain SEC reporting requirements. Most notably is a compensation disclosure analysis, which is included in registration statements as well as in proxy statements. For proxy statements, an internally managed BDC must have a say on pay vote as well as a frequency of say on pay vote. The say on pay vote is effectively an advisory vote, and shareholders will either approve or disapprove of management's compensation for the prior fiscal year. The frequency of say on pay vote is effectively a 1 or 2 year period in which the say on pay vote will be held. I will note that emerging growth companies are not required to have compensation disclosure analysis. Their executive compensation disclosure in the proxy statement and registration statements is scaled back. They also are not required to have a say on pay vote.
So what about the external structure? How does that differentiate itself?
Yeah, So the external structure is much different than the internally managed structure. In the external structure, the day-to-day operations and effectively the portfolio management is managed by an external investment advisor. The BDC will also have an external administrator that will provide the administrative services and equipment necessary for the day-to-day operations of the BDC. Now, the investment advisor to a BDC must be registered for the SEC under the Advisors Act using Form 80. Now, the BDC and the investment advisor will enter into an investment advisory agreement, and the administrator in the BDC will enter into an administration agreement. Typically, these agreements are separate agreements. The reason for this is that for an investment advisory agreement, if there's any material changes to it, it requires shareholder approval. So many times BDCs will have a separate administration agreement in case they want to make any adjustments to that agreement and the services provided by the administrator. Now, I will note in the investment advisor agreement will set forth the services to be provided by the investment advisor, as well as the fees to be paid by the BDC to the investment advisor. Now, this is where BDCs are a little bit different from other closed-end funds, and that primarily relates to the fees. The BDC, or an investment advisor to a BDC, can earn a management fee, an incentive fee on income, and an incentive fee on capital gains. However, other closed-end funds that are not BDCs can only receive, the investment advisors to those funds can only receive a management fee and an incentive fee on income. They cannot receive an incentive fee on capital gains. Now, and I should also mention that the incentive fee on income, as well as the incentive fee on income, is subject to certain hurdle and catch-up features. Now, all of these aspects of the investment advisor agreement are disclosed in the BDC's registration statements and other public reporting, pursuant to other public reporting requirements. The BDC, or the SEC, has not taken a formal position on how those fees should be calculated, but again, it's thoroughly disclosed by the BDCs.
And in the externally managed structure, you would have a situation where the board would have to weigh in on that on an annual basis, right? They'd have to review. And
yeah, that's absolutely. I'm glad you bring that up, Cynthia. That's correct. So even at the initial term, or if there's a material amendment, shareholders have to approve the investment advisor agreement. Further, each year at the annual renewal period, the board of directors, including the majority of independent directors, must approve the investment advisor agreement. And this involves a very thorough review of the investment advisor agreement, including comparing the fees and assets under management to comparable BDCs.
So another area, valuation. BDCs, it's very uncommon that they have an illiquid portfolio almost entirely composed of debt or equity. And you're required under the 40 Act to value that portfolio on a quarterly basis. How is that put together, and what does fair value mean for the 40 Act?
Oh, yeah, of course. Yeah, that's correct, Cynthia. So on a quarterly basis, BDCs have to determine their net asset value. And as a part of that process, they need to determine the fair value of their investment portfolio, specifically for the investments that do not have readily available quoted prices. Now, BDCs will follow ASC 820, which basically sets forth the requirements for measuring fair value in accordance with GAAP. So fair value is defined in ASC 820 and is defined as the price that would be received to sell an asset or paid to transfer liability in an orderly transaction between market participants as of the measure date. More simply, this is a reasonable price, or this is the price that a BDC can reasonably expect to receive in an arm's length transaction. Now, in determining fair value, a BDC that's internally managed will have its management team prepare certain valuation materials. In the external structure, the investment advisor will prepare certain fair valuation materials. There will also be an valuation firm that will produce valuations as well. Now, either the management team in the internal structure or the advisor in the external structure will review the valuation prepared by the third-party valuation firm and overcome or discuss any discrepancy between those valuations. At that point, they'll prepare a full set of materials that will then be provided to a valuation committee or an audit committee. Some BDCs will have a valuation committee that primarily focuses on valuation, whereas other BDCs will not have a valuation committee, and the audit committee will take on that role. Now, the management team or the advisor will make a full presentation to either the valuation committee or the audit committee on the proposed valuations of the various portfolio investments. The audit committee or valuation committee will then approve a recommendation to the board to approve those valuations, and at a subsequent meeting, the board will then approve the fair valuations based on the materials presented to them. And this, as you mentioned, this is done on a quarterly basis and is required on the 40 Act.
Great. Well, and then one of the other areas that we wanted to talk about when you're operating a BDC is the tax treatment or the tax consequences. Maybe you can talk about that for a minute.
Yes, certainly. So BDCs can elect to be treated for U.S. federal income tax purposes as a RIC, or regulated investment company. Now, as a RIC, a BDC is permitted to have pass-through tax treatment, meaning that any income or capital gains distributed to shareholders are not subject at the BDC level to federal income tax. Now, in order to qualify as a RIC, a BDC has to meet 3 separate requirements. The first is an annual distribution requirement. The second is an annual source of income or test. And the third is quarterly diversification test. And the annual distribution requirement, the BDC must distribute at least 90% of its investments, or 90% of its investment income to shareholders annually, and at least 98% to avoid an excise tax, which is currently at 4%. For the annual source of income test, the BDC, 90% of the BDC's annual gross income must be good BRIC income, meaning interest, dividends, gains, and certain types of fees. For the quarterly diversification test, at least 50% of the BDC's total assets must be invested in cash, governmental securities, BRIC securities, securities of other RICs, and other securities of other issuers, which cannot be more than 5% of the BDC's total assets or more than 10% of the issuer's voting stock. In addition, no more than 25% of the RIC's assets may be invested in any one issuer, and no more than 25% of the RIC's total assets may be invested in a qualified, publicly traded partnership. Further, BDCs provides, as RICs, BDCs receive certain beneficial tax treatment, as we mentioned, namely the pass-through tax treatment. An investment in BDC can also provide certain tax benefits to certain types of investors, such as a non-U.S. investor or a tax-exempt investor. Non-U.S. investors that invest in partnerships, for example, could be subject to effectively connected income, which is known as ECI. Tax-exempt investors could be subject to unrelated business taxable income, known as UBTI. So in short, a BDC as a RIC can effectively act as a corporate blocker for UBTI and ECI. Further, there's no withholding tax on interest-related dividends, short-term capital gain dividends, or long-term capital gain dividends.
Wow. So when you're putting together or structuring a BDC, there's quite a few things that you got to take into account.
That's certainly right, Cynthia. It is a complicated process, and we enjoy working with our clients through the various questions and issues that arise as they develop, form, and launch BDCs.
Thank you very much, Darius. Have a good day. Hello, this is Cynthia Cruz, and we've been talking about BDC 101, and now we're going to talk about corporate governance. And I have Jen Howard with me, an associate in the capital markets group, who's going to help us out. So Jen, tell me about the BDC's board of directors and the role they play in the overall governance for a fund or BDC.
Sure. So a BDC's board of directors is actually its most effective corporate governance tool and is responsible for the general oversight of the operation of the BDC on a day-to-day basis, and is tasked to make sure that the BDC is operating in the best interests of its shareholders. A BDC's board has to consist of a majority of independent directors, which is governed by the 1940 Act definition and generally requires that a majority of the board not be affiliated with the company or the fund platform in any way, and also catches anyone who's engaged in a transaction with the company or the platform or has some other type of material business relationship with the company. The general responsibilities of a BDC's board include things like approving the advisory contract between the BDC and the advisor, determining the fair value of a BDC's portfolio investments on a quarterly basis, and also reviewing other various compliance matters that come up during the year. Also, state law imposes traditional corporate responsibilities and fiduciary duties on a BDC's board. For example, many BDCs are organized as Maryland corporations, which state law imposes a requirement for those BDCs to have an annual shareholder meeting, among other items. And another note is that the obligations and fiduciary duties of a board of a private and public BDC are actually generally the same. However, stock exchange requirements for publicly listed BDCs do impose some additional corporate governance items, such as specific requirements for audit or nominating committees and requirements that independent directors hold regular executive sessions.
So they're the gatekeepers, and it's actually
Exactly.
it's basically instituted through the 40 Act, which is in addition to what you would have through a normal state of incorporation. So just how does a BDC board typically designate their committees, or how do they use their committees, and what's their process and like?
Sure. So committees actually play a very important role for BDCs, and BDC boards will establish a variety of committees that have specific ongoing responsibilities and duties on a regular basis. The most important, or committee that has the most work to do for a BDC, is their audit committee. The audit committee will review and approve the regular SEC financial statements, will also be the regular body that engages with the BDC's accounting firm, both in connection with the audit process and otherwise, and will also pre-approve any services to be provided by that audit firm. The securities laws and stock exchange rules also impose different independence requirements for members of the audit committee, which go along with the requirements in the 40 Act. And then the audit committee will meet in executive session with the audit firm for the BDC on a regular basis. Another committee that BDCs often use is a nominating and corporate governance committee. This committee will review and approve nominations for directors to the BDC's board. Also, the committee will review and ratify independence of directors, as we discussed earlier, and then will sometimes determine the composition of the other committees of the board. Some BDCs also use a valuation committee, which is tasked with the responsibility to review and determine fair value of the BDC's portfolio investments on a quarterly basis. A BDC will also sometimes use a compensation committee. This is actually required by the stock exchange rules for publicly listed BDCs. For an externally managed BDC, the compensation committee's most important job is to review and approve the advisory agreement between the BDC and its advisor. And then for internally managed BDCs, the compensation committee will review and approve the executive compensation structure for the company's management.
Mm-hmm.
There are a couple of other types of committees that some BDCs use, but not all. For example, if a BDC is engaging in a strategic transaction or some other extraordinary event, they may appoint a special committee of the independent directors only. Also, some larger BDCs or BDCs on large fund platforms will use a compliance committee or a co-investment committee to review and approve specific co-investment transactions under SEC relief that the BDC has received.
Okay, so to do all those things, how often does the BDC board meet, and what are they generally covering, whether it's on a regular basis or on an annual basis?
Yeah, so as you would imagine, a BDC's board has to hold a regular quarterly meeting to accomplish many of these tasks. They'll also hold additional special meetings as the need arises, and the BDC's audit committee will also generally meet on a quarterly basis to review and approve financial statements that will be included in the upcoming SEC filing for the BDC. Other committees typically meet annually or maybe on an as-needed basis as an item arises that the committee is responsible for. There are a variety of attendees at these meetings. Obviously, the members of the board or the particular committee, the members of the funds management team, and then representatives of certain outside service providers such as auditors, legal counsel, fund administrators, or independent third-party valuation firms. There'll also be one attendee at the meeting whose job it is to take minutes of the meeting for record-keeping purposes. Typical quarterly meeting agenda can have a variety of items on it. Usually that will include reviewing and approving minutes from the prior meetings, reviewing and determining fair value of the BDC's investments, getting a general update on the BDC's business plan and strategy for management,
a compliance report from the BDC's chief compliance officer, usually a regulatory update from the BDC's legal counsel, and then also any other necessary approvals of material contracts or offering documents or other items that are going on in the BDC's world at that time. And then typically every meeting will end with an executive session of the independent directors with the CCO or with the company's outside legal counsel.
Great. And what kind of policies or procedures would the board generally have in place in order to meet all these requirements?
Yeah. So typically at its very first organizational board meeting, a BDC will adopt a variety of different policies and procedures to satisfy these requirements under the 40 Act, under state law, under stock exchange rules, or any other applicable rules. To start, the 40 Act requires that a BDC adopt a compliance program that's supervised by a chief compliance officer, and many of these policies and procedures sit under this larger compliance program. BDCs will generally have a 38A1 compliance manual that summarizes the program and includes a lot of these policies and procedures and how the BDC CCO and management team will implement them.
Mm-hmm.
A BDC also has to adopt a code of ethics, which is a governing document that is designed to prevent insiders of the BDC from engaging in any fraudulent behavior, and usually requires a regular report of their trading in the BDC securities to avoid any inside trading issues. Also, under Sarbanes-Oxley, a BDC has to adopt what's called a code of business conduct, and this specifically applies to the senior financial officers of the BDC and comes into play to ensure that those financial officers are promoting honest conduct in the BDC and are ensuring that financial related disclosure is accurate and timely. Also, specific requirement of the New York Stock Exchange for any BDCs that are listed on the NYSE is for them to adopt what are called corporate governance guidelines. These are general guidelines that govern the behavior and personal conduct of employees and directors of the BDC and summarize the company's approach in that regard. And then lastly, each committee of the BDC, as we discussed earlier, will adopt a charter that governs the operations of that particular committee and sets forth their responsibilities on a quarterly and annual basis in terms of what documents they review and approve and how often they meet. In general, the board of the BDC will review and approve these policies on a regular basis and as they are amended.
Wow. So how does the board get all these things and committees, how do they pull all this together, make sure that this is all done correctly?
So usually they use their legal counsel to get all of these done correctly, which we can always help with, and work together with the CCO and other members of the BDC's management team to get everything done and give the board a good set of documents to review and approve.
Great. Well, thank you very much, Jen. I appreciate it. Thanks.
Sure.